All right, thank you for joining us for the event tonight with Keenan Crow, Director of Policy and Advocacy for One Iowa. This is co-sponsored by the City of Iowa City Office of Equity and Human Rights and the Iowa City Public Library. Today's event is part of the Iowa City Public Library's annual Carol Spaziani Intellectual Freedom Festival. This is a series of events for all ages that affirm our right to freedom of thought and expression. The festival was established in 1995 to honor Carol's 27-year career here at ICPL and her lifelong commitment to the freedom of ideas. For more information about this year's programming, please visit icpl.org/IFF or take one of our event calendars at the back. We invite you all to join our event tomorrow afternoon at 4 o'clock here in the same space with the Obermann Center for Advanced Studies for a program called Scrutinizing the Shelves, Banned Books and Obermann Conversation. That will be panelists discussing the history of book bans in the Midwest as well as nationally, and look forward to a future with access to books for all. For tonight's program, please hold your questions until the end of the presentation. There'll be ample time. We'll come around with a mic so that those watching on the live stream can hear your questions as well. Our presenter tonight, Keenan Crow, is the Director of Policy and Advocacy at One Iowa, a statewide LGBTQ advocacy organization. Keenan is One Iowa's staff lobbyist and spokesperson on policy issues. They are on the front lines of the fight for LGBTQ equality in the state of Iowa. Additionally, Keenan has worked to train a diverse number of organizations and institutions around LGBTQ issues, including K-6 educators, local and federal agencies, businesses, and healthcare providers. In 2019, they became the first non-binary person to moderate a presidential forum. They are the recipient of the 2023 Interfaith Alliance of Iowa Partner Award and the 2023 Iowa Environmental Council's Impact Through Advocacy Award. Please join me in welcoming Keenan.
Thank you. Much appreciated. Thank you for the warm introduction. As was stated, my name is Keenan Crow. I use they and them pronouns, a non-binary Iowan, and I'm here to talk to you a little bit today about censorship and how a particular group of anti-LGBTQ politicians, not just here in Iowa but across the country, have embraced censorship in the guise of removing materials, primarily materials featuring authors that are LGBTQ and people of color. So the beginning of the presentation, I will just kind of generally flesh out the Iowa political sphere around LGBTQ issues, how we got to this point in the first place, where we're going from here, etc. Then we will dive into the actual text of some of these bills. I know the big one everybody wants to hear about is the book ban, but there are a couple others that we will hit on as well that also impact education policy, but I do promise to confine myself to education policy this time, and we won't hit housing or plumbing codes or any fun stuff like that, which are some of my favorite topics most of the time. So let's start here. Because I never know exactly where the audience is on LGBTQ terminology, and if I kind of don't do this first, it's going to get very confusing for a couple of the folks that aren't familiar with these terms. So the LGBTQ acronym is really made up of two different concepts, right? Sexual orientation, which is who we're attracted to, who we have relationships with, and gender identity, which is how we see ourselves in a gendered sense in the world. So lesbian, gay, and bisexual are all types of sexual orientation. Another very common sexual orientation is straight. That is also a sexual orientation, right? One thing that you're going to find, especially with the folks that are writing these laws, is they somehow believe that sexual orientation and gender identity are only things that apply to LGBTQ people, and that is simply not the case. Everybody in this room, everybody that we meet, everybody has both a sexual orientation and a gender identity. Now, whether those sexual orientations and gender identities make them part of the LGBTQ community is a totally different point. But just so we're aware, if we ban discussion of sexual orientation, that also bans discussion of straight people. So that's a tough bar to clear. The question is always, will a judge see it that way? And obviously not, right? They're thinking in the same kind of vein that some of these legislators are thinking of, but it opens up our available arguments a little bit when folks don't understand kind of the baseline term. It is important to understand that these are two separate things, right? That everybody has both of these, not just one or the other. Also that they're not like interpolable. Not every trans person is gay, not every gay person is trans. In fact, those things are completely separate. Your sexual orientation is relative to your gender identity. So if we're making like a little math equation out of it, the gender identity has to come first, and then from there we can calculate the sexual orientation based on who we know that person is attracted to, right? But if we're going into the policy side, if we don't have both of these things enumerated, we have left out an entire chunk of the LGBTQ community. That could be for a reasonable reason, right? Like something that just doesn't apply to sexual orientation that for some reason does apply to gender identity, but it can also create really horrible policies as well. So for instance, in the state of Iowa, it is a hate crime to assault a black person for being black, a Jewish person for being Jewish, a gay person for being gay, because sexual orientation is a class under our hate crime statute, but not to assault a transgender person for being transgender, because gender identity is not an enumerated class under our hate crimes statute. So especially in the policy realm, we have to be really careful with these terms and know exactly what we're talking about before we can dive into those policies, because otherwise we're going to create something that actually doesn't do what we have intended it to do, or maybe we're doing it on purpose. It just depends. So let's talk about the policy landscape here in Iowa. Iowa is roughly in the middle of the pack when it comes to affirmative protections for LGBTQ people. We have anti-discrimination protections for sexual orientation and gender identity, both as enumerated classes, and we have since 2007. Now, some of those protections have been weakened in recent years by adding exceptions to them, carving different spots out of them, but the fact that we have them at all puts us ahead of about half of the states in the country. There is no federal anti-discrimination statute in the United States. It does not exist. It is left up to the states, and that means that there is like a patchwork of different protections based on which state you are in at any given point, right? So Iowa has protections in the areas of education, employment, credit practices, public accommodations, and housing. For credit practices, for instance, we're one of only 17 states that has that protection. And so in any other state, if you wanted to deny a credit card for a transgender person simply because they're transgender, you are able to do that without any sort of legal repercussion, at least at the moment. So it's a much worse situation than most folks imagine. A lot of folks, about 90% of Americans, believe that we are protecting these folks in this way at a federal level, and that is simply not true. That is not statutorily a thing. Now, there is an attempt to make that statutory, and that is what is called the Equality Act. That's a piece of legislation that has been introduced in Congress for the past several years. It has cleared the House for several years in a row, but has not ever made it past the Senate. There is one kind of small exception to this, and that is, even though we don't have any statutory protections, there are some protections because of the interpretation of the Supreme Court case, which is called Bostock v. Clayton County. And Bostock was really about the question of, is discrimination based on sexual orientation or discrimination based on gender identity, are those things just different forms of sex discrimination? Because sex discrimination is statutorily prohibited in the areas of employment and several others. And so the argument kind of goes like this, right? If you would fire a man because he's married to a man, but you wouldn't fire a woman for being married to a man, aren't you in fact forced to take the sex of the people you're trying to discriminate into account? And isn't that in fact just a form of sex discrimination, right? Ditto for gender identity. If you fire someone who is assigned male at birth for wearing what we will call traditionally feminine clothing, but you wouldn't fire somebody assigned female at birth for wearing what we would call traditional feminine clothing, again, aren't you in fact taking the sex of that person into account and using sex stereotypes to make that determination? And even Justice Gorsuch, who is very conservative, wrote the opinion in this case in 2020, said, yeah, actually that is just a form of sex discrimination. There's really no other way to slice that, right? And so because of that Supreme Court case, nationwide employment discrimination on the basis of sexual orientation or gender identity is now prohibited. Again, not statutorily, because of this Supreme Court case that tells us that those forms of discrimination are in fact sex discrimination. So that's kind of where we're at there. Now the question is, how far does that apply in other areas, right? Like if that applies in the case of employment, shouldn't it also apply in the case of housing? Shouldn't it also apply in other areas where people are federally prohibited from discriminating on the basis of sex? And I think yes. I don't see how you get around that argument. But because of where the court is, and because they are kind of in an ideological block more than a legal reasoning block right now, we are a little bit worried about how those next cases are going to go. And we can't confidently say that those things are going to come out in the way that we would like them to, even though I think the rationale holds very firmly. Who knows what the Supreme Court is going to give us with the exception to why housing discrimination is not like employment discrimination, right? They could come up with conceivably all sorts of different reasons why those two things are different, and therefore why the Bostock case doesn't apply. But we will continue to insist that because of the rationale in Bostock, it does apply nationwide to a number of other areas, and one of those areas is education policy. Now, attacks on LGBTQ folks have been getting worse rather than getting better, unfortunately. And this graph is really all the active bills in a given year. It's not the number of introduced bills in a given year, and I'll tell you why. The Iowa legislature operates in 2-year increments, right? And so in the first year of a 2-year increment, you're working with a blank slate. In other words, you have no legislation at the start of the year, and any legislation that you introduce, that goes in the active pool. The second year, however, all the legislation that was introduced in the first year automatically becomes active at the beginning of the second year as well, and then it stacks on top of whatever legislation there was. So 2019 is year one, right? We've got 5 bills introduced. 2020, we get 9 bills introduced, and that stacks for 14 that we actually have to fight at any given time. Ditto, so 2021 we get 15 introduced, and then 2022 we only get 13 introduced, but we are still fighting 28 of them all at the same time. Now I will say in 2023, that was a blank slate year and we had 29 introduced. And so we will be fighting that plus whatever else is introduced next year as well. It will be a very difficult and challenging session. Now what are those bills? What do they do? I've kind of broken them down into 6 different categories. So category number 1, the red, are obscenity bills. These are kind of like the book bans. I've also classified things that criminalize trans people's bodies being in public spaces, so things that say that it's obscene, for instance, for a trans man to not wear a shirt at the pool, something like that. The blue are civil rights rollbacks, so these are poking holes in, making pieces weaker in our civil rights protections, or removing classes as a whole. There has been a move amongst a certain group of very extreme folks in the Iowa legislature for the past 4 years or so to remove gender identity as a class from the Iowa Civil Rights Act, effectively stripping every protection for transgender Iowans that we have. Orange are medical care denials, that's obvious. Yellow are religious exemptions. These are pieces of legislation that allow people to pick and choose which laws they would like to follow based on whatever religious beliefs they're professing at the time. Purple are bathroom bills, and then this green area, the thing that gets bigger every single year, are the anti-education policy bills, right? The things that target kids specifically in schools. So we knew this was coming. We saw it year over year, and that's exactly what happened. They were finally able to get several of these pieces of legislation across the finish line, 4 pieces to be exact, and we'll go through 3 of those tonight, one of which is the gender affirming care ban. Doesn't really have a whole lot to do with education policy or book bans, so I will skip that one. These are not bills that legislators are coming up with like because a constituent came to them and said, this book hurts my feelings, right? Like that's not what these are. And you can tell that because you will find verbatim versions of this legislation introduced in basically every state that has a Republican trifecta, regardless of what it looks like. So you will see basically this is a piece of legislation that the only thing has changed is the name of the state in the piece of legislation, right? And there are a number of groups responsible for this, primarily American Principles Project, Alliance Defending Freedom, Heritage Foundation, Family Policy Alliance, all 4 of which have joined a disgustingly named coalition called the Promise to America's Children Coalition. And the exponential growth from 2019 until today is not just in Iowa. Iowa is a microcosm of what's happening nationwide. So you start in 2019 with about 80-ish pieces of anti-LGBTQ legislation. That goes up to 180 in 2020. It goes up to 280 in 2021. It goes up to 380 in 2022. We're over 500 now for 2023. So this is not something in any way that is unique to Iowa. It is, again, a push by a number of national organizations, which is why you see those numbers mirrored in the legislatures all across the country as well. As I said, it is getting worse rather than better here in Iowa. Part of that is because our pro-equality legislative numbers have shrunk significantly, not just from the general election in 2022, but in particular in the primary elections in 2022, where a lot of moderates on our issues were ousted, and in some cases replaced with explicitly anti-LGBTQ folks. So a good example here would be Dustin Haidt, who was in the Pella area. He was the former chair of the House Education Committee. I would not say that Dustin is necessarily an LGBTQ ally by any means, but he was more of a moderate. He wasn't interested in, that stuff was not his top priority by any means necessary. Now the person that sits in that seat is Helena Hayes, and she runs an explicitly anti-LGBTQ hate group called Protect My Innocence. And so when you have people like that who have significant amounts of power, this is the kind of legislation that you get. Here's just an example of some of the things that we saw during the campaign, things that will probably not surprise you, but saying that Democrats want a drag queen in every school, that people are letting folks out of prison simply because they're transgender, that there's porn in children's libraries, all this kind of stuff. This is all a lie, by the way. Like everything on the screen right now that you're seeing is a total and complete lie. But just to give you a temperature check on where the rhetoric has been going as of recent. So what were the 4 bills that were signed into law by the governor? And then we'll go through them kind of piece by piece if they're education policy. As I said, the gender affirming care ban for those under 18, I'm not going to tackle that tonight. There's too much there. SF482 is a school bathroom bill that forces trans students into unsafe bathrooms. It requires that people use the bathroom of their sex assigned at birth. I will note in particular on this one that since 2007, students had been able to use the restroom that matched their gender identity. And so in some cases, there were kids who had been using, let's say it's a trans boy, right? They had been using the boys' restroom for like over a decade, and then overnight are forced into the girls' restroom. It's incredibly disruptive. It doesn't solve anything, doesn't make anybody's life better, but it does make these kids' lives a lot worse in the process. And then SF496, we will spend most of our time on that this evening because there is so much in there. It's kind of an amalgamation of a whole bunch of horrible ideas that they've been working on for quite some time. Number 1 is the Don't Say Gay, Don't Say Trans. That's K through 6. That prohibits anybody from talking about sexual orientation or gender identity until grade 7. The forcible outing of transgender students if they confide in staff. It removes info about HIV and HPV from curricular requirements, bans all books with any depictions or descriptions of sex acts in school libraries and curricula K through 12, and then it creates a Parents' Bill of Rights. And in that Parents' Bill of Rights, you will see a number of different enumerated things, like the parents have the ultimate authority to direct their child's education, direct their child's morality, direct their child's health care. Oh, but asterisk, actually we're going to say explicitly that, yeah, they have the absolute right to direct their child's health care unless their kid is transgender, because we're going to ban that. And so we don't want to put anything into that law that undermines us in the courts. Now, personally, I think that explicitly saying except trans kids is going to actually make it worse for them in the courts. But that's not for me to judge. That's for an actual judge. And then finally, SF560, which as a whole is fine, but there is a specific provision in it. So this is a blanket budget bill, which means that there are like 20 different divisions and it's like 300 pages long, right? And most of the stuff is good. It funds education services. That's great. But in Division 5, they've created a freeze on DEI efforts at Regents institutions. It creates a mandatory report to be delivered to the legislature. I'll talk about that in more detail and why that's a problem as we go through, but just wanted to throw that on your radar. The confusion is intentional. They are not writing these laws because they are crystal clear and everybody understands what they mean, right? There are some things that we simply don't know what they mean, and that is by design. The Department of Education has told districts not to expect additional guidance, which is typically what would happen with a very vague law like this. And legislators are doing this because they're counting on the law being vague so that they can take credit for any enforcement actions that they do like, right? Oh, this book came out of the schools. We like that, so that's us. We did that. And then we can kind of disown any enforcement that they find distasteful. Ooh, Urbandale removed 1984. Well, we like that book. So we'll say that didn't mean that. We didn't like that part. So, you know, and a great example is that the two education committee chairs. So these are the folks that are arguably most responsible for this legislation, Senator Ken Rosenboom and Representative Schuyler Wheeler. They disagree about what it means and what it says. They're the people that wrote it, and they can't even come to agreement on what it's supposed to do. Schuyler says that books can have LGBTQ characters in them. Ken says they can't have LGBTQ characters in them. So if we're disagreeing about a fundamental component of the law, that is not a clear law, right? Even the people who wrote it, and they continue to insist that it is crystal clear, by the way, as they disagree with each other, which is like kind of funny, but in a very dark and horrible way. You have to laugh at this stuff and the absurdities. I don't know any other strategy aside from just like crying up here at you. The other thing I want to impart on you is that authoritarianism works in a very specific way and it has predictable patterns. And one of those patterns is that people tend to help the authoritarians so that they aren't called out in the future, right? One of the ways that people will try to minimize their own risk in these situations is they will take it upon themselves and go further than a law requires, simply so that they're not even close to the gray area. And I want to tell you, don't do that. Don't do that. Don't help them. Make them force you to do whatever it is that's ultimately going to hurt a kid, right? Don't voluntarily hurt children. I know that that sounds obvious in you know, kind of on its own, but in context, it actually is really difficult for people to determine where that line is and where they're not going to help, right? So, number one, we should never, in any circumstances, allow school officials to go past what the law requires. There is an effort to do this, a very real effort to do this. Number one, because a number of different school districts are listening to kind of the same legal organization, which is giving them tips on how to enforce this. And one of the tips they're giving is make a policy that can apply to every single building. And what that means is take the don't say gay, don't say trans stuff from K to 6 all the way to K through 12, just so that you can have uniform policy across your district, right? Don't let them do that. That is going to hurt kids. Don't help. Don't help. We should push back even against known legal requirements when they're going to hurt kids. We have a moral obligation to resist immoral laws in the same way we have a moral obligation to follow the moral ones. This is immoral. Push back as hard as you can and as often as you can. Now, we will point out the bounds of the law here as I see them so that everybody can make an informed decision about their words and actions and how far they're willing to go, how close to the line they're willing to get and whether or not they're willing to cross it. Those are ultimately individual moral decisions, but I don't want to make it seem like, oh, let's just all follow this law very piously. No, this law is horrible and it's killing kids already. And so we shouldn't be following it. We should find every way we can to poke holes in it. So let's start with the bathroom bill. The bathroom bill, the actual text of the bill is, it says that a school shall require a multiple occupancy restroom or changing area to be designated only for and used by persons of the same sex. A person shall not enter a multiple occupancy restroom or changing area or a single occupancy restroom or changing area designated only for persons of the same sex that does not correspond with the person's sex. And sex, in this instance, is not defined in code, is defined as a person's biological sex as male or female as listed on a person's official birth certificate issued at or near the time of a person's birth. So sex means whatever's on your original birth certificate. That's all it means. So that means that transgender students will no longer be able to use restrooms that correspond to their gender identities if policies are changed in response to a complaint. And that is one thing that I actually want to bring up because the enforcement mechanism relies on complaints. If no complaint is made, nothing has to happen. Great. So don't put policies in place until someone complains, because that is exactly the mechanism that we're talking about, right? If someone does complain, a district then has 3 days to cure that violation before the Attorney General can bring any legal action. So the worst thing that happens if you don't do anything and don't institute this policy is that somebody complains, and then you change your policy, and then nothing happens. So what is the incentive to change your policy ahead of time? There isn't one. Why help? Why help? Don't go past. Yeah.
Sorry, I didn't mean to interrupt. But who can complain?
Anyone.
Anybody.
Yeah.
So I can go into somebody else's school and complain about their bathroom.
Yes.
All right.
The question for those online was who can complain, and the answer is anyone. The answer is anybody that happens to know that a transgender person is using the restroom. Now, you have to have like specific evidence of that, right? Like you have to say it's this person, they're using the restroom, it's at this school, all that stuff. You can't just generically say, I think this district is doing trans stuff. That doesn't work. But yeah, it can be anybody. Number one thing to advocate for is not changing the policy at all until you get a complaint. Number two thing to advocate for is accessible single-stall facilities that any student can use regardless of their gender or their sex assigned at birth, because what we're about to go into here in a little while is that any trans student that asks for an accommodation, that immediately gets reported back to their parents. Now, if there are facilities that are just accessible to anyone, they don't have to ask for the accommodation, there doesn't need to be a report back to their parents, they're not outed automatically, all that good stuff. So that is kind of what we should be pushing for in our individual school districts to make sure that we reduce that harm. The actual text of the don't say gay and don't say trans bit. It says a school district shall not provide any program, curriculum, test, survey, questionnaire, promotion, or instruction relating to gender identity or sexual orientation to students in kindergarten through grade 6. One thing that I will point out that's kind of interesting is originally in that list of things, test, survey, questionnaire, blah, 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 they had announcement, and now there's no longer announcement. So I guess you can make announcements about gender identity and sexual orientation as long as they are not programs, curriculum, tests, survey, questionnaire, promotion, or instruction. Announcements, totally cool. Very silly. Again, as I said, there are folks trying to get this through K through 12. And so we should push back aggressively when that policy comes in, as it's going to do far more harm than already exists. I will note, and contra Senator Ken Rosenblum, that this does not require that books with LGBTQ characters be removed. Representation in literature is not instruction, it's not curriculum, it's not a test, it's not a survey, it's not a questionnaire, it's not promotion, it's not any of those things. If you read the law very carefully, which I suggest Senator Rosenblum do, it doesn't require that. The only thing that it says about library books is that they can't have descriptions of sex acts. Just because somebody is gay in a book does not mean that there's a description of a sex act in it. That's an absurd reading, and even among the numerous, I think, valid readings you could come up with, not even in the reasonable camp of different kinds of readings. So why you're all here, I imagine, is the book ban language. The actual language says each school district shall establish a kindergarten through grade 12 library program that is consistent with 280.6 and with the educational standards established in this section, contains only age-appropriate materials and supports the student achievement goals of the total school. And age-appropriate is then redefined from how it was before, and it says that it does not include any material with descriptions or visual depictions of a sex act as defined in section 702.17. If you're interested, you can go read 702.17. It has things that you would probably imagine in it. That means any book with any depiction of sex acts has to be removed from school library shelves, right? And there has been quite a bit of debate on what that actually means. It seems like it would be straightforward, but the easy example here, I think, to go back to is 1984 again. 1984 has a sex scene in it. Now, it is not a particularly graphic sex scene, it's not particularly descriptive, but it does, in fact, describe a sex act, right? And so by the plain reading of the text, it seems like that should be prohibited. Now, legislators are coming out and saying, that's not our legislative intent, and that's not what we mean to do, and we just meant, very graphic depictions of sex acts. Well, it doesn't say graphic anywhere, does it? Is the problem. They apparently left that word out, and even if they had put it in, would need to define it regardless. So we're kind of left with, well, how explicit does it have to be before it triggers that threshold? And I don't have an answer. Unfortunately, nobody knows, because this is all we have to work with, right? There's no additional guidance. There's no additional anything. And so does 1984 meet the criteria? We don't know. That's the only answer I can give you. We don't know. I hope not. I think that the most dystopian thing possible is banning the book 1984. But it may, yeah.
Point of order, 702.17, is that in the SF496, or is that some other section of the code?
So yeah, the question is 702.17 the section of the code that SF496 deals with? The answer is no. It is a separate code reference, and it's primarily for the list of things that will ultimately give you a sexual assault charge. Next section is about trans student accommodations. There are a number of different sections in this law. So the actual text of this is, if a student is enrolled in a school district and requests an accommodation that is intended to affirm the student's gender identity from a licensed practitioner employed by the school district, including a request that the licensed practitioner address the student using a name or pronoun that is different from the name or pronoun assigned to the student in the school district's registration forms or records, the practitioner shall report the student's request to an administrator employed by the district, and the administrator shall report the student's request to the student's parent or guardian. So the long and short of that is, if trans students want to use the name that they go by, if they want to use the pronouns they go by, they have to have their parents' permission in order to do that, right? It also automatically notifies parents after an incident of bullying, and it can potentially out those students if the bullying is related to their sexual orientation or gender identity, because again, we have a mandatory report going back to the parents. Now, some people don't see this as a huge problem. Let me tell you why it is. About 10% of our youth population here in the US is identified as LGBTQ. About 40% of our homeless youth population in the US is identified as LGBTQ. It can be incredibly risky if somebody outs you against your will. Those folks, the folks who are being outed, it's their information to control, right? It's their story. They shouldn't have to tell it to anybody that they don't want to, and they certainly shouldn't have to have that facilitated by a school administrator, because they are the ones that know what their risk level is intuitively. They know how their parents are going to react. They know what they're going to say. They know what they're going to do, right? And even if it doesn't raise to the level of losing your home, maybe it's losing access to the family car or your cell phone or social media or money for college or whatever it is that somebody can hold over your head. That is a very dangerous situation. There has been a little bit of a dust-up around this particular policy, and one of the reasons is because some districts are essentially just sending notes home to everybody who uses a nickname at all for any reason, right? You've probably seen posts about this kind of across. I think that's a reasonable reading. There are a couple different ways that you can read this text, but I think that it's really difficult. So imagine that we've got a kid named Samantha, and they ask to go by the nickname Sam. Well, how do you know if that's a request that is intended to affirm the student's gender identity or not? I can't really think of a way to do that. I mean, sure, you could say, is this intended to affirm your gender identity? And if the student wants to use their nickname, they're just going to say no. And then what? Like, I mean, there's no good way to actually tell whether that is there or not. And so I understand why districts are doing that. I think the other interesting component is there are a lot of parents of cisgender kids just now realizing what trans kids are going through, because they're getting this note home now and going, well, this is a ridiculous waste of my time. And then they have to think, why did they do that? Oh, well, it was primarily to waste the time of trans kids, right? So I think that there is probably a more narrow reading of this that could be interpreted, and the Des Moines school system has made a relatively narrow reading. Essentially, they're saying, unless the student explicitly says, I am a trans man, I was assigned female at birth, and now I am transitioning to be a boy, and therefore, I want you to change my name. That is when it triggers the report home, and nothing less, essentially. Now, I think that that has problems because we are singling out and targeting just trans students for differential treatment under that policy. That is not good. But I do think ultimately that allows non-binary kids to use the pronoun that they want, use the name that they want. And so, again, this is all about harm reduction and trying to find which interpretation harms the fewest kids. And I think that's probably it, even though we are differentially treating kind of binary trans people versus non-binary trans people in a different way. There's another component in here, and that is the law strikes state requirements for info about HIV that's supposed to be HPV. I don't know why I didn't change that. HIV, HPV, and the vaccination around HPV. One thing that you should know is that Iowa actually has the #1 incidence of HPV-related cancers right now, the #1 incidence. And 90% of those cancers could be prevented with the HPV vaccine. It is the only cancer prevention vaccine that we have right now. Why, as the #1 state in the country at the moment, are we removing this info? Why are we taking this info away from students? That's absurd. So the good news about this one, if there is such a thing, is that it's not prohibited from the curricula. It is simply no longer required. And so one thing that you can do to ensure that this info is still there is make sure that your school board members keep it in your district, because they are allowed to do that. They're allowed to continue those requirements at a district by district level. So the more districts we can agree to keep that info, the better. There is a very little known part of SF496, and that is the data collection prohibitions. So actual text on this is each school district is prohibited from administering or conducting an invasive physical exam of student or student health screening that is not required by state or federal law, or a formal examination or survey of a student that is designed to assess the student's mental health, emotional or physical health, that is not required by state or federal law without first requiring written consent of the student's parent or guardian. So what does that mean? It takes the surveying system from opt-out to opt-in, which means we don't have as much data anymore, right? I don't know if any of you have ever tried to collect parental signatures for a field trip before, but those things don't come back very often, I will just say. And so if you take something from opt-out to opt-in like they've done, what that does is it really compromises the amount of data that we're able to collect, and therefore how reflective that data actually is of the student population. That really compromises our ability to evaluate the interventions that we're introducing to reduce high-risk behaviors, right? Drinking, drug use, sexual activity, self-harm, all those things that we want data on, that we want to know, hey, if we do X, Y will happen, we now will not arguably have. The other thing is that the state is now refusing to do sexual orientation and gender identity for their BORFIS study, which they have done in the past, and so we won't have any way to measure how harmful this is to LGBTQ folks. That's what this all comes down to, right? They're removing our source of data to demonstrate how bad these laws actually are and how many people they're impacting. I told you I'd talk about SF560. So Division 5 of SF560 contains provisions that freeze all DEI spending and hiring for the year, and then it also requires a report to be submitted to the legislature before 2024. If you were a student or staff member at a Regent University, you probably received a survey at the beginning of the year asking you about those DEI efforts, right? Why did they do that? Well, let me tell you, this ain't a fact-finding inquiry. They're not doing this so that they can find out more information about DEI programs. At the beginning of the year, they introduced this bill, HSB 218, and that deletes DEI programs from every university in the state. It means you can't spend $1 on DEI programming. It means you can't hire any staff related to DEI programming. It is an effective DEI ban across the board. They couldn't get that across the finish line, right? So what is this? This is justification for getting this across the finish line. That's all it is. We already know what the conclusion is from this quote-unquote survey or study or whatever you want to call it. And the conclusion is DEI is bad and it's a waste of our money. I can already tell you what they're going to say before the report comes out. That's what the report will say, guaranteed. I will bet anybody $500 on that right here and now, because I know this is what we're going for. And it may even go further than that, right? We've seen in Florida, they are now restricting DEI services at businesses, private businesses. They're also restricting it in professional development programs. It's a pretty good rule of thumb. Watch the Florida legislature this year, and you'll know exactly what the Iowa legislature is going to introduce next year. They are the most Me Too about Florida that I have ever seen in my entire life. It's like they think that Florida is the be-all and end-all. Let me tell you, Florida's got beaches and sun. Iowa doesn't have that. We have to do a little bit better than Florida. All right, so post-session, what are we watching for? Number one is implementation and enforcement, right? How are districts actually going to implement this? And as I've said before, since we don't have statewide guidance to intervene on, we actually have to watch kind of every individual school district and see how they are implementing it. Urbandale had a particularly horrible implementation of it a few months back, where they banned about 400 books from their school, and then they had to peel that back. I think that the number is down to 60 now, which is still an obscenely high number, but it's not as bad as 400, right? And they are also on the list of folks that we believe are ultimately going to attempt to move to the K through 12 model around Don't Say Gay. Obviously, there are still opportunities for administrative rulemaking to happen. I don't think that it will, but it's possible. And there are, of course, opportunities for executive orders or other executive branch actions like AG actions, things like that, since the AG is involved in the enforcement mechanisms for these. But ultimately, what we're really watching is local and county governments and school boards, because they're the only folks with any sort of maneuverability at this stage, which is why we're now involved in school board races and a number of other things, because that's our only chance for harm reduction. Now that these policies have passed, there's no undoing them, at least for several years, until we get different people in that legislature. So 2024, as I said before, all the bills that weren't passed or were tabled for whatever reason, so we had 29 introduced, 4 passed, that means 25 come back automatically on January, whatever it is, 12th or whatever the day it is the legislature starts. They will be automatically reactivated. So everything that you've seen us talk about up to that point will be on the table again. Some legislators have already been telegraphing what their plans are for next year. The 2 big words are religious exemptions, as I think we talked about those a little bit. So those can take a number of different forms. I think what they really want is something called a RFRA, or stands for Religious Freedom Restoration Act. And this is a very broad piece of policy that essentially says, you get to pick and choose which laws you want to follow based on whatever religious beliefs you have or can profess at the time. Obviously, it's impossible to see what people actually believe, right? So that could, somebody could reasonably say, for instance, my religion allows me to discipline my spouse and child as I see fit. So domestic violence laws, they don't apply to me. I don't care. Now, would they necessarily win? No, but they could take that to court. They can make that argument, and it is going to encourage people to test the bounds of those policies and behave badly, thinking that the courts are ultimately going to save them because of that religious exemption. The other thing, if they can't get the RFRA through, if they don't have enough momentum for that, what they will go for is a bill that got through Senate committee this year but wasn't actually voted on in the Senate. It's a bill that would allow religious exemptions for healthcare providers in particular. So somebody could essentially pick and choose which patients they want to see based on their religious beliefs. I don't think I have to tell you why that's a terrible idea and what things could go horribly wrong there. In ed policy, like I said, DEI bans and restrictions on professional development, I think we're very likely to see those come back. And then expansion of existing anti-LGBTQ policies. I know that there are going to be districts who implement the K through 12 thing. I think the legislature is going to come back and try to expand the grade range that they have already had and probably, make it a little bit more aggressive and put in more aggressive enforcement mechanisms in particular. I envision, for instance, the bathroom bill having a much more rigorous enforcement mechanism in the future. So that's roughly kind of where we're headed. It's not a terribly encouraging trajectory that we're headed toward, but that's why we need everybody in this room to help us out, to contact their legislatures, to get in touch with these folks, and to start getting active with their school boards, and make sure you vote in the school board elections that are coming up in November, because not a lot of folks tend to vote on those. And so if we can get even everybody in this room to vote in the school board elections, we will be well on our way to having more folks who are in positions of power that actually care about what happens to these LGBTQ young people. We've got real problems to think about, right? It's not like we, twiddle our thumbs with all this useless anti-LGBTQ policy and nothing bad happens. In fact, it's making the existing problems even worse. So this is data that was all collected in 2022. This is data on the general population that was collected in 2021. This is LGBTQ youth data. This is general BERFIS data. If you cross-reference them, though, you're getting at about 2 times the level of suicidal kids. You're getting 61% compared to 39% experiencing depression. These are horrifying statistics, right? 22% is a horrifying statistic in and of itself. I don't want to downplay that at all. 22% of our young people thinking about suicide in the last year is something that we need to take very seriously. 44% is something that we need to be appalled by. It's something that we need to take immediate action on, because that is something that is costing people their lives every single month. And we've already seen multiple kids fall from a lot of this new legislation. So it's not theoretical harm. This is something that kids are dying from all the time already, unfortunately. We can do better. We do not currently prohibit conversion therapy, which is a dangerous, discredited practice aimed at changing the gender identity or sexual orientation of a young person. We don't prohibit the gay and trans panic defenses, which are discriminatory legal strategies that seek to excuse murders and assaults simply because of the gender identity or sexual orientation of the victim. We don't recognize bias-motivated crimes or hate crimes committed against transgender people as hate crimes. We don't prevent student groups at colleges and universities from using student fees for discriminatory purposes. That actually happened because of a case at the U of I campus, believe it or not. We don't allow for gender-neutral markers on official documents. We don't allow youth to access medically necessary gender-affirming care. We don't allow youth to access the appropriate restrooms in schools, and we certainly do not allow inclusive, honest, age-appropriate curricula. We can't mention LGBTQ people in grades K through 6. That's not honest, right? We can't discuss systemic racism, sexism, homophobia, any of that stuff, because it hurts people's feelings too much. And so they had to create a divisive concepts policy to make sure that we didn't talk about that. And you can't have books on the shelves that give young people honest, accurate information about their bodies. Stuff that they need to protect themselves, stuff that they need to protect their partners, stuff they need to protect the rest of the community in a lot of different situations. So we've got a lot of work to do. Unfortunately, we're going in the opposite direction, and we're not doing any of this work. So I would like to get to a point where I can do some of this work, where we can get some of these policies passed that we actually need to combat this number right here. So I will now open it up for questions, and I know that there's going to be a mic that folks are passing around, so please wait for the mic to come to you before you ask your question so that everybody on the stream can hear.
Thank you. I'll just come around with the mic, and just a couple ground rules before we start questions is, number one, we'll just be respectful of one another in our questions. This is a great time to ask Keenan anything you have about the presentation. Number two is, maybe if you're thinking more of a comment than a question in your brain before you speak, maybe just hold that for a minute and see if you can come to a question. And if not, there's plenty of time after the Q&A session here to come and just chat with Keenan too. Okay?
Thank you. My question is, if a teacher chooses to refer to all students as they, them, and a student who identifies as female says, I'd rather you say she.
Yeah.
Isn't that a request based on gender identity?
Yeah.
That the teacher would not be able to honor?
They'd have to ask their parents, I think. Yeah.
Okay. Okay. Just wondering. I was just...
At least in my reading, again, this is all about whether or not you can convince a judge, right?
Right.
And so realistically, do I think that that is actually going to trigger enforcement? Probably not. Do I think that you have a reasonable read of the text? Yes. I think that that's an accurate reading of the text.
Thank you.
Wave, not a hand.
These statutes that have passed so far, all of them appear contestable. Are you aware of any challenges forthcoming or anticipated, and which ones?
One thing that I can't talk about is like potential legal cases in the future. Rest assured that we are having those conversations, but I can't get into a whole lot of specificity about those. Good question, though. I wish I could tell you.
Yeah, my question is when it comes to the ideas of freedom of speech.
Yeah.
For example, what's your view on the idea of compelled speech and whether there should be criminal or civil penalties?
That's a really broad question. So,
Well, I mean, as far as like with gender and stuff, like let's say
Yeah.
somebody says, let's say a student, for example, comes into a class, informs her teacher, I would prefer to be referred to as they, them, any other gender. And for whatever reason they choose, they don't feel comfortable with that, then how is it really fair to either side?
Sure. Yeah, it is hard to answer the question without getting into the actual principle, right? So that's why I was kind of thinking a little bit more globally about it. There are a few different things to say about that. Number one, as a private citizen, I don't believe that anybody should be, in a situation of compelled speech. Period. The end. If you're, a random person on the street and somebody says, "Hey, call me she, her," and you say, "Screw you," that should not have any sort of enforcement mechanism at all, right? Like that's just interpersonal interactions. It gets a little bit different when you are someone in a public education situation because then you are actually acting in a capacity as a state actor, right? And so we have some additional qualifications that we tend to put on state actors. We tend to say, look, your speech is curtailed to a certain extent, right? Like you can't lead a prayer in school. That's one of the things that you can't do. You can't tell your students to vote one way or another. You have to interact with students in a way that is appropriate. You couldn't say sexual things to a student, for instance, because that would generally be viewed as inappropriate. So what I would say is that there are certain kind of standards of conduct, and one of those is generally that we refer to people in the way that they ask us to refer to them. So for instance, a student could get in trouble for not calling somebody Mr. Dietz, right? Like if they just said, "Hey, Tom," they would probably be asked very politely to say, "No, in this situation, my name is Mr. Dietz," and in order to facilitate kind of mutual respect among students and staff, can you please refer to that? And if they didn't agree to that, they would then probably be sent to the principal or have some sort of other disciplinary action taken, right? So in this particular situation, what I would say is it is kind of a matter of mutual respect to just use the name and the pronouns that the student has given you. And ditto for, I guess the other kind of confounding thing here is right now, there actually is a compelled speech statute, right? Right now, the teachers are forced to use whatever is on the registration form. They can't use whatever the student requests. They have to use whatever is on that piece of paper. So right now, there is already a compelled speech happening. They are forced to, in some cases, use the incorrect name. I don't necessarily think that that is a free speech issue because, again, we're in the state actor realm. And so the same kinds of rules don't apply. I do think that we have to hit a level where we say, okay, this is respectful and kind of this isn't. And so we're going to say teachers have to engage in respectful conduct with their students. And that generally means using the name and pronouns that that student has. Now, should they go to jail for it? No, that's absolutely absurd. But could they incur discipline in their job and in their capacity as a state actor? Yes, I think that's a reasonable nexus. Does that make sense?
Well, yes and no. I don't know. I guess because it's a contractual situation.
Yeah.
So, but honestly, I think that's a slippery slope to potentially lose a lot of rights that people don't realize just how quickly they can go away.
Yeah. I guess I would ask, do you feel the same about the current compelled speech statute that says they have to refer to them as the wrong name?
Honestly, since I don't have any children that are school age, it's not really an issue, but it is something I'm just kind of thinking. It's kind of intrigued just about compelled speech in general, regardless of this scenario or the situation.
Yeah, it's a good question, and I appreciate it. Thank you.
I'm curious, at the beginning of the presentation, you mentioned an organization that was providing school districts guidance because we know the DE has been really silent on this. Yeah. And in fact has come out and said, we're not really providing guidance. And the one thing that they did release really didn't do much.
It didn't
by way
say
of that.
anything,
Yeah.
really.
Yeah, exactly.
It was like, do what the law says.
But you
And
did
you're like, okay.
say at the beginning that there was an organization that was providing some guidance.
Yes.
Is it IASB, SAI?
It's the legal firm that generally represents the school districts, which I can't remember the name of off the top of my head. Allers, I want to say. Does that sound right? There's one legal firm that the Iowa Association of School Districts uses, and that's generally the firm that is advising districts at this point. Yeah.
I can't remember the name of the Supreme Court justice, but they said that the rights of students do not stop at the schoolhouse gates regarding a T-shirt freedom of speech discussion. Has there been any challenges on the constitutional basis of the rights of students to be able to identify as they see fit?
It's a good question. Not in Iowa, certainly. Unfortunately, there was just a case that came down yesterday that essentially reinforced the policy that we just saw, right? That teachers have to use the name that's on the form unless the parent consents. That said, that was a county court. It wasn't like a federal court or anything like that. But that's the only case that I've been aware of recently. I know also the Linmar case came down recently as well, and there was a bit in there that essentially said saying that students have to quote unquote respect each other is just like too vague and too broad. So that really didn't change any sort of policy because we don't really know what the requirements around that are. But I anticipate, because so many states are moving these forward, that we will have an answer on that within the next 5 years or so. Good question.
So in my class that I'm in currently, we're talking about culturally responsive teaching.
Yes.
And one thing that we're taught throughout the entire time through the College of Education is creating a welcoming and like calm environment for students, so it's easier for them to learn in. But how can we create that for students who are part of the LGBTQ community?
Yes.
And when there's all these laws there, because I feel like it would make it a lot difficult for them to feel safe in the school, which is going to just make it harder for them to even want to learn.
Yeah, you're right. There's no easy answer to your question aside from no, that there is no way to actually do that in like a holistic way, because there are so many things preventing you from doing the right thing, right? There are so many statutes that are standing in your way of validating those kids' identities. What you can do is everything that you can do. And I know that that sounds very kind of vague and amorphous, but whatever district you end up teaching in is going to have a very kind of specific interpretation of this, and there's going to be loopholes. And so you look and you try to find every loophole you can to support those kids, and you let them know in no uncertain terms that you support every kid, regardless of who they are, and that you're a safe person to come to. Now, in regards to the like automatic reporting, one of the things that you can do and still stay within the bounds of the law is just let students know exactly what the bounds of the law are, right? Like if you tell me X, Y, or Z, I have to tell your parents. If you tell me A, B, and C, though, I don't have to tell your parents. And so if you don't want anything communicated back to your parents, don't tell me X, Y, and Z, and then you'll be okay. Now, that's not as good as just being that open door that anybody can come in and tell you everything, right? That's not even close to as good, but it's better, and it doesn't get kids outed against their will. And so, again, we're looking at harm reduction strategies and not so much harm avoidance strategies in these cases.
You spoke earlier about the enforcement mechanism for the bathroom bill being reliant on complaints.
Yeah.
Is that the same for the name and pronouns piece?
It is not, unfortunately. So the name and pronouns piece, the mechanism is a teacher hears it, they have to then immediately report it to an administrator, and then the administrator has to immediately report it back to the parent. There's a number of ways that could happen without a complaint, right? Like if another student overhears that conversation, then they could report that to the administrator and get the teacher in trouble. If an administrator overhears a teacher talking about it, they could report the teacher, get the teacher in trouble. And so, the enforcement mechanism ultimately is complaint-based, right? Like it's about whether or not you're reporting things back, but since there's kind of multiple stages along the way, it makes it harder to avoid getting hit with a complaint. Not only that, With the bathroom bill, there's a cure period, right? Like after you've been identified as violating it, there's a 3-day period where you can just be like, okay, we changed our policy now, and nothing happens. With the name and pronoun thing, that's not the case. The first time it's immediately you're going to the disciplinary board, the Iowa Department of Educational Examiners. And the other tricky factor about this is there's no time period. So first thing is like a warning from the board, and then the second is like actual discipline from the board, and there's no time period that delimits that. So like imagine you're in your first year of teaching and you get your first ding, well then 20 years later you get your second ding, that still counts and you're still gonna get disciplined just as hard for that second ding 20 years later. So it's a much more strict regime, and there's a lot more opportunities to get caught up in the disciplinary process there.
Can they discipline everyone?
No. Ultimately, there's only so many teachers, and if everybody rebels, that's going to be a totally different thing, right? The other thing that I will mention, just as a global thing, is that none of this applies to students. Students can call each other whatever they want, generally, and if the entire class, when a teacher uses the incorrect name for a student because they're required to by law, if the entire class wants to retort their actual name, they can totally do that. Like, there's nothing illegal about that. If they want to bring a banned book to school and share it with all their friends, they can totally do that. There's no law against that. This only applies to educators and administrators. Those are the only people that are constrained. So if students want to step up to the plate and intervene on some of this stuff, which I would, encourage them to do, not a whole lot of consequences for students in these particular policies.
Does this apply equally to private schools and public schools?
Oh, that's a great question. No. I'm sure you'll be shocked to know that these don't all apply to private schools, despite all the money that we are now sending to those particular schools. Now, some do. Some of these things actually do apply to private schools, but not most of them. In fact, most of them are pretty much completely in the realm of the public schools. So yeah, the voucher law is a big problem, and that's one of the reasons, right? Like generally with a competition, everybody plays by the same rules, and that ain't the case with vouchers. Public and private, two different sets of rules that they're playing by right now.
The legislature has been pretty good about not really being clear on a lot of things.
Yes.
And are there clear enforcement penalties in place for any of these statutes?
Some yes, some no. Generally, the penalties themselves are not spelled out, but the process of like going through and evaluating them is spelled out. So a lot of these are basically going back to licensure, and the Board of Educational Examiners is going to handle kind of the vast bulk of what's in SF496. There are no explicit penalties laid out, right? It could be anything from a slap on the wrist to complete loss of licensure. It could be kind of anything the Board of Educational Examiners deems as a reasonable outcome. In terms of the bathroom bill, that's enforced by the Attorney General. Some of these others are enforced by other mechanisms. There are private causes of action for the bathroom bill, for instance, so a citizen could bring suit in those cases. So it's kind of all over the board, but there's nothing in there that says that, like, if you have this book in your library, then this specific thing happens. That doesn't exist.
So if a teacher or a school should choose to try to test the limit on a vague statute, they're really not sure what can be done to them. Or
correct. Not. And that's part of how it works, right? There is just like a massive fear of what kind of reaction there is going to be to this. Is there going to be like, if I call a student their name or pronoun that they want to call them, do I then like lose my license and cannot teach ever again? That's a plausible outcome. I don't know how likely it is, but that from the text, you can derive that, right? That could happen conceivably. And so until like the first person gets hit with it, everybody is going to be just shaking in their boots trying to not get up to that line. And again, that is ultimately what causes people to help authoritarians, right? They don't want to hit the line, and so they're going to do everything in their power to like distance themselves from that line as much as possible, and that's why you get those kind of snowball effects from those really vague policies. Now, vague policymaking is, I think, actually probably a good thing in the long run for a number of different reasons, which I won't go into. But the only thing that makes vague policymaking feasible is when you have administrative agencies then willing to issue guidance and specificity on it. So it's not so much that the law is vague, because that's the case with most laws. It's more so that the state is not willing to kind of drill down and actually define what it is after the vague policy has been passed. If that makes sense.
What are teachers' unions' role in this? Like, do they have any abilities within advocacy efforts or anything like that?
Yeah, I mean, if you're a teacher and you have a question on whether or not, you can do X, Y, or Z, the first person you should go to is your union rep, like 100% of the time. The school lawyer is going to have a very conservative interpretation of whatever it is, and it's often even more aggressive than what the law actually requires. The union rep is going to have a decent idea of like, okay, yeah, that's where the law is, but this is where I can defend you, right? Like, this is where I can protect your job. And that's going to be a different answer than the school lawyer is going to give, or the district lawyer, or whoever it happens to be. So the role of teachers' unions in this is, number one, just to support those folks and what they're going through, but number two, to give really clear answers about, here are the bounds in which we think you are reasonably behaving, and here are the bounds in which we think that this is maybe too far and you're likely to get into legal trouble. Now, again, they're not going to say, you can do this, it's just you're going to get into legal trouble. But that is always kind of what you should think in the back of your mind is, okay, now this is too far, and am I willing to risk this potential consequence for doing this thing? Good question. We work with teachers' unions quite closely on just thinking about how to talk about these policies as a whole. They're a great resource because they just have so much background and knowledge on how these things have been enforced in the past, which points to how they're likely to be enforced in the future. Other questions?
Early in the presentation, you talked about a number of organizations that sort of formed a
Yes.
larger coalition to create the language
Protect
for some of these.
America's children, yeah.
Yeah. Are there coalitions or groups of organizations, like what efforts are happening on the opposite side of that? And can we, is that where our role comes in?
Sure.
Yeah.
Yeah, it's a great question. I can't think of a lot of formal coalitions that are like at the same scale as what I identified there, right? Like that is far and away something that we do not have the resources to fight, to be completely honest with you. And that there are not a whole lot of resources left in the movement to fight. Now, I will say that there are a number of organizations working on this stuff, right? ACLU, Family Equality at the national level, HRC at the national level. Here in the state of Iowa, ourselves, ACLU of Iowa, Interfaith Alliance of Iowa, Annie's Foundation, the ISEA, we are all coalescing around getting information out on the school board races and things like that so that folks can be better informed as to what's happening. I'm doing events like this. I'm also doing Banned Book Week in Beaverdale on Friday, Saturday, I can't remember. And that is another amalgamation of different groups that are working on this. But generally it's like, the ACLU, the librarian organizations, the free speech organizations, even on the conservative side, so FIRE, free speech and individual rights in education, I believe is what that stands for, but they're more of a conservative free speech org. They're against this stuff too, because they know what happens when books get banned. So this particular issue makes odd bedfellows, I will say. We work with some folks that we wouldn't typically work with simply because of the free speech principles that are kind of at risk in these situations. So is there a big, scary coalition on our side? No, unfortunately. Is there one on their side? Yes. Again, very unfortunately. Do I know of an effort to actually come up with something on our side? No. Is that pretty typical for what happens in these kinds of conflicts? Yes. Should we have more infrastructure? Yes. I unfortunately don't have easy answers for that one.
Yeah, so I had a question about the limitations that are being inflicted
Yeah.
Because of the law, do they only pertain to like physical limitations, like on school property? Like my question is, if a teacher can take children on a field trip to, let's say, someplace where books aren't banned, like the public library, and maybe slip them a list of all the books that are banned in their, in their library at the school, or can they like start a club? Yeah, sorry.
So there are a few things that have a nexus around school property and events, which would also consider them off school property. That's like the restroom restrictions, right? That happens not just on school property, but also for any field trip, overnight, anything like that. So there is that. Some of the practitioner-related stuff is just based on you being a practitioner. So as a practitioner, you can't say X, Y, or Z in any situation, regardless of where you are physically located. The book one is actually a very good question, and I haven't had that question before. And the reason that one is a good question is because the language around this, let's find the actual language around this, right? The language around the book ban says, each school district shall establish a kindergarten through grade 12 library program that is consistent with Section 280 and with the educational standards established in this section, contains only age-appropriate materials and supports the student, and then age-appropriate is divided that way. It doesn't say anything about going to a public library. It doesn't say you can't go to a public library. It doesn't say you can't allow students to check out a book at a public library. It just says you can't have these in the school library, and that you can't talk about sexual orientation and gender identity grades K through 6. So if you've got a high school student and you wanted to take a trip to the public library, I don't see anything in this text that prohibits that.
If the schools are not allowed to teach sex education, what mechanisms would be available for the students to gain that information?
Yeah, the answer is bad ones. If students don't learn sex education in school, they generally learn it from a few different sources. Now, the best possible scenario is that their parents actually talk to them, right? That doesn't happen as much as we'd like it to, which is why schools have sex education in the first place, because those kids weren't getting that information and STDs were running rampant and, the whole 9 yards. So the most likely place that they're going to get it is the internet, and the most likely place on the internet they're going to get it is porn, and we all know that that's a terrible place for them to get that information, right? Like, that's not an accurate depiction of sex between adults. It certainly doesn't use safer sex practices most of the time. It doesn't talk about the risks, the emotional components of it. It doesn't talk about anything particularly useful, and it doesn't even really describe the mechanics accurately either. So the real answer is that they will probably get it from really bad sources. The other thing to think about is, if a kid really wants to see porn, is the first place they're going to go the school library? I don't think so. That wouldn't be the first. I mean, that wasn't the first place that I went when I was at school, and we didn't really have internet access at the time. So I'll just tell you that that's not happening. Like, I don't think that that is a realistic concern that people have. To answer your question, I think ultimately what happens, and we see this in state after state that moves to these kinds of abstinence-only models, right, where they're not actually being honest with kids about sex. What we see is STI rates go up, teen pregnancies go up, abortions tend to go up. There's all sorts of things that we say that we don't like that increase when we don't have accurate, comprehensive sex education, and that's really what we're risking. And so I think your question is instructive in terms of where will they get it? Well, nowhere that it's actually going to be honest with them, unfortunately, except for maybe their parents. But again, that happens less frequently than we'd like it to.
Under the law, when does a when does a teacher stop being a teacher? Now, I ask this question because
that's a great question, actually.
I imagine a lot of teachers that are involved in youth organizations and developing relationships out of the classroom, especially at the high school level and middle school level. And has that been defined? Because I can see a situation where someone from their youth group that they're involved in, the student tells them that, I have whatever it may be, and
that's a good question. it's not crystal clear, but generally the way that courts have defined it is if there's like a nexus to official capacity, right? Like, so they're on school grounds, or they're instructing a student during a field trip, or there's some other nexus around this person clearly has authority in this situation and is in their capacity kind of as a state actor, right? If you are coaching a t-ball team or something, you don't really have that same nexus there, right? If you're at your church youth group, you don't really have that same nexus. And so I don't think that just because somebody is a teacher that they are kind of like gagged forever, right, on this stuff. I think plausibly when you're off school grounds and you're in a non-teaching activity or capacity that you kind of stop being a teacher. I don't know how to say that, but I hope that that answers your question. You have to have something to kind of point to authority in some way and point to the fact that they're acting in an official way. Yeah.
I was curious about this opt-in for questionnaires and surveys for the kids, because if good chance teenagers don't always tell the truth in a survey, sure. But it seems to me that there's, if by disrupting this data collection, that's going to disrupt how you, adopt new policies, maybe how you allocate resources,
Absolutely.
Whether you can apply maybe for federal grants or other grants from nonprofits. So can you talk about the ripple effect that this could have?
Yes. Now I will say in terms of like the federal grants, they have specifically kind of carved that out in that they say if something is required by federal law, then they'll do it, right? Or something is required by state law, then they'll do it, and they won't force people to opt in. But you're exactly right, and that's actually a feature and not a bug of the policy, if that makes sense. The idea is that we don't have data to evaluate our interventions because they know that this particular intervention is going to be bad and it's going to show all sorts of harm caused to these students. And so better axe that before we get data after the policy is passed so that we don't know. It's also because they're trying, there's kind of a bigger push to just get rid of sex education in schools, right? We've already removed all the books that have any sort of descriptions of sex ed, so sex education is going to be kind of weird already because can't talk about sex acts in it, which is wild. But aside from that, the move is to go to abstinence only. And again, when we see systems going to abstinence only, increase in teen pregnancies, increase in risky behaviors, increase in STI transmission, increase in all this other stuff, they don't want to see that demonstrated because they know what the data is going to be around the policies. So the feature is shut up so that we can enact whatever we want, and that way you don't have any data. And if you do say it's harming X, Y, or Z kids, they'll say, well, you can't prove that. Right.
My question kind of builds off of Mitch's of when does a teacher stop being a teacher, but when does someone become a teacher if you're not officially, so let's say that I work for UAY and I come in and run a group, or I run G World, or I come in as someone in the College of Ed at Iowa and I run a group with it. Do I then have to? It depends on the statute. So one example here with the trans student accommodations, this says a licensed practitioner. So if you don't have a license, not a teacher. In this instance, right? So that's kind of an interesting nexus around that. There are some policies, though, that also apply to staff, to paraeducators, to other things like that. So the don't say gay, don't say trans thing, for instance, that says a school district shall not, and so the district is on the hook in that case for anything that's taught within kind of their walls or that nexus that we talked about previously of their official capacity, right? So if somebody, a paraeducator or somebody from a nonprofit came in and did something like this for a K through 6 group, the school district would still be on the hook. Would that individual person be on the hook? No, but the district would be. And so there are mechanisms kind of around that, if that makes sense. So not everybody who
could get the district in trouble has to be a teacher or has to have the license or has to have that nexus around it. Some of them are resolved exclusively for the district, and some of them are reserved exclusively for the administrators. In other words, the administrator could lose their license or get in trouble in some way because of something that somebody came in and did. So you always have to kind of keep that in your mind as well. Like if you're taking an action that could in some way plausibly violate a law, are the consequences just for you? In which case, if you're okay with the consequences, do it, right? Like that's what civil disobedience is. But if the consequence plausibly could impact other people, then I'd say that that's a totally different moral calculation. You have to be a lot more careful because then you're risking other people's livelihoods and not just your own. That's not the same thing. Yeah.
I have been...
You're on.
I've been wondering since all of this came about in regards to school counselors, how it's not a HIPAA violation. But now that I'm looking at this, I am wondering if there is a difference between employed by and contracted with. Like if somebody is, say, employed by Psych Associates,
yeah,
which contracts with the school.
Yeah, so I mean, again, this says licensed practitioner, and so does the counselor have a license?
I mean, they would, but then
Right.
it's the affirmed by the school or employed by the school part that I'm questioning. Employed
That
by
is
the
a great
school
question.
district.
So we don't know what this means, to be completely honest with you. We don't know what the nexus is around it. I will say that plausibly right now, what we have is two different readings of that situation, right? I think there is one reading that says that this means directly employed by the district, not contracted out, right? I think there's another reading, and I think it's the more popular reading among the lawyers that are telling people what to do right now, and that is that right now counselors are put in an impossible scenario where they're asked by the state law to do one thing and they're asked by their professional licensing body and code of ethics to do something totally different, and that there is no winning in that situation, right? That they could plausibly lose their license from the state for doing X, but they could plausibly lose their license from the licensing body for not doing X. And so there's no way to both do and not do X at the same time, right? But I do think that you're onto something there in terms of employed by the school district. I think if somebody challenged that, I would need to look at our employment statutes and actually see what that word means and whether contractors count. Anyone else? Going once? Going twice?
Thoroughly exhausted all of our
So.
questions. Yeah. All right. Well, thank you everyone for coming and for all your questions, and thank you, Keenan.
Thank you.